on environmental justice, a call for mediation, organized by Center for Environmental Law, Policy, Education and Development, also known as CELPED, ICFAI Law School, the ICFAI University, Dehradun, in collaboration with Brunel University. I would like to take the privilege to extend a heartwarming welcome to our speaker for the day, Professor Dr. Kenneth Frank, Professor and Director, Conflict Resolution and Legal Studies, Brunel University, Gainesville, Georgia. Thank you, sir. Thank you for accepting our invitation and gracing the event with your valuable presence. I would like to extend a warm welcome to Mrs. Monica Kharola, Assistant Dean, ICFAI Law School, the ICFAI University, Dehradun, and all the participants who have joined us today. Moving forward, now I would request Mrs. Monica Kharola, Assistant Dean, ICFAI Law School, Dehradun, for welcome address. Over to you, ma'am.
Thank you, Anushmi. It's my privilege to welcome our guest speaker today, Professor Dr. Kenneth Frank from Brunel University, Georgia. And also I would like to tell them a little bit about ICFAI Law School. This ICFAI University, Dehradun, started in 2003 as a private self-financed university. And our law school started from the year 2003. Over this period of time, we have had some very good results in terms of producing judges and good lawyers who are now practicing in the corporate field, because of which the strength of the school has grown. And today we are ranked among the top law colleges in India by some of the ranking agencies. Like we were ranked 13 among the best schools of eminence in India, and this was rated by the Career 360 Survey 2021. Then we were also ranked 13 among top law colleges by IIRF ranking 2021. We were ranked first among the law schools in this state of Uttarakhand by CSR GHRDC Survey 2021, and ranked fifth among top leading law schools of super excellence by CSR GHRDC Survey 2021. So I would like to inform that the faculties and the students of ICFAI Law School are continuously improving and doing their best in order to achieve the goals set by this university to make the students great lawyers in the coming days. In this endeavor of ours, we have established the Center for Environmental Law, Policy, Education and Development under the excellent guidance of our previous Dean, Sir, Professor Yugal Kishore, Sir, who is here with us today. And I thank him for showing us this way and for helping us in order to achieve new heights. So in this journey of ours, we have tried to have more lectures from eminent personalities who can talk to the students and inform them about the latest developments in different fields like environmental law, cyber law, IPR, and human rights and humanitarian law. So to make these centers of excellence at power and make them thought-provoking and help in developing the research of the students and the faculties included, we have had some very good lectures, and this is another lecture for telling the participants about what is their possibilities about ADR in environmental justice system. So this effort of ours, I'm sure, will take the law school to a higher ranking and will help us to give to the students the best that we can give for enhancing their knowledge and helping them to become good lawyers, good researchers in the days to come. With these words, I once again welcome the guest speaker for today, Professor Dr. Kenneth Frank, and thank him for agreeing to deliver this lecture on a very important topic, because today ADR has become one of the important means by which disputes can be settled among countries and even under the municipal laws. So it's been excellent that we have got this opportunity. Thank you once again, sir, for being with us. And over to Vishal now. Thank you.
I would now take this opportunity to welcome our chief guest speaker of the day, Professor Dr. Kenneth Frank, who holds a JD in law from University of Colorado and a master degree in conflict resolution from Columbia College. Presently, he is the director of the undergraduate degree program in conflict resolution and legal studies at Brunel University, Ainsville, Georgia. He has received the Anne Austin Johnston Outstanding Faculty Award from Brunel University, as well as the 2015 Coach of the Year Award from the International Academy of Dispute Resolution, that is INADR. He is also the chair of the International Intercollegiate Mediation Tournament Board on the board of directors for INADR and is currently serving as the vice president for education USA for that group. In addition, he has been a trainer, consultant for many organizations on the topics of conflict resolution, mediation, civility, and was recently awarded an honorary doctorate from the University of Georgia. He is also a co-founder of the consultant group that is Transforming Mediation LLC, which is a registered neutral with the state of Georgia. We welcome you, sir, for the special guest lecture. Thank you so much, sir, for accepting our invitation for the same. Over to you, sir.
Well, thank you very much for that kind introduction. Dean Carolla and Professor Berra, the two of you have been most gracious in your comments. I have enjoyed the opportunity to work with Vishal Berra as we have placed this lecture on your schedule, and I am deeply honored to be here today to talk to you and your students. It is our desire to establish connections between our universities. I think we can do some good work together, and I look forward to working with you in the future. And I am most impressed with the quality of your programs and the quality of your faculty and students. And I hope that we will continue to do good work together. So I am really honored to be here. And I want to express to you that I will welcome any questions that you may have at the conclusion of the comments. And I also am hopeful that if you have any additional questions, you will not hesitate to reach out and contact me. There'll be some contact information at the end of the lecture. But I am just delighted to be here, and I want to use our time together as much as we can. So if you will permit me, I will go ahead and share my screen.
Yes, sir. Surely, sir. You've been a co-host. You can share the screen, sir.
All right, are you able to see the first slide?
Yes, sir.
All right, good. Well, the topic that I would like to talk about today is environmental justice, a call for mediation. And I will be coming with some ideas from the United States, but I do believe that these ideas will apply as well in your country, and that India it's just a little behind us in terms of the development of mediation in many areas of law. I've been involved in mediation since 1988, and mediation really called to me when I was in the practice of law, because I would see developments in mediation that I thought were much better than what was happening in the courtroom. So I want to emphasize that that my comments are somewhat centered in the United States, but I do believe that they will have application for you as well. And I want to be sure that these comments are something that you can use in your work too. So the theme for today is environmental justice, and it's a call for the use of mediation in environmental justice, because it's my belief that mediation holds the key to be able to resolve a lot of the problems that exist in environmental law and environmental justice. So I'm going to proceed from that point. I have been sufficiently introduced, so let's talk a little bit about what we're going to see today. I want to briefly talk about conflict. I want to talk about the choices when you're facing conflict. We'll talk a little about environmental justice, and then we'll talk about some environmental mediations that have occurred in this country that I think suggest possible routes for environmental mediations in other areas as well. And we'll talk about why they succeeded and what that success looks like. We're also going to talk about restorative justice as a model for mediation of environmental issues, and that will take us to the conclusion. So let's talk about a brief review of conflict. You know, it's been my position that there's a group that is very afraid and adverse to conflict, and that's a lot of lawyers. They tend to, when emotion gets high in the mediation room, they want to go to caucus. They don't want to really have that conflict play out in front of them. But conflict is an opportunity. And it's really the only opportunity we have to address some of the issues that we have. So one look at conflict says that conflict is created when our values and our needs and desires clash with someone else. And conflict is so easily created. Anyone that you have a relationship with, whether it's within your family, at one of your coworkers, also between organizations, and even between countries. And because we have relationships with all these, conflict is universal, but conflict is not something to be afraid of. The trick is, how do you respond to conflict? And here's where I think we get some real interesting choices. In front of you, you have a continuum. On the left, you have avoidance. On the right, you have going to courts. You know, it's interesting, in the United States, in some of our federal district courts, over 94% of the cases that are filed in the federal courts are now settling. They're not going to a full-blown trial. They're not going to adjudication. The reason for that, a lot of that has to do with these intermediate steps, particularly negotiation and mediation. And so even though cases are being filed in our federal district courts, they are not moving to a trial. And so I am talking to some of the future leaders in your country, and you as future leaders need to recognize the power of negotiation and mediation as avenues for resolving dispute. Not everything you do is going to wind up in the courtroom. I know when back in the Stone Age, when I went to law school, we prepared everything as if it were going to the courtroom. But today, that's not nearly as true. And the skills that you can acquire in negotiation and in how to address mediation are going to be the most valuable skills you can bring for your clients, because that's how most cases are going to get resolved. You'll notice on the little continuum, the two ends of the continuum have some criteria that are really important. The further to the right you go on that continuum, the more control you as the disputants lose over the dispute, and the more of that control you give away. Also, there is a level of formality that increases as you go to the right. The most formal process we have, of course, is the courtroom. And also, as a general rule, the amount of money that you have to spend to resolve the conflict increases as you go to the right. So there are very, very good reasons to stay on the left side of this continuum, particularly in negotiation and mediation, because those are the two where you are able to continue to control the outcome of the case. I used to regularly appear in front of a judge, and that judge would always order pretrial statements to be submitted to the court, and he would have a very formal pretrial conference in the courtroom with all the trappings of the court. He was up on the bench in robes. The one attorney and his client would be on the right, one attorney and her client be on the left, and it was a very formal thing with the bailiffs and the clerks and the court reporters and everybody else present. He would look at these pretrial statements and he would routinely find something on the pretrial statement he didn't like to see. He didn't want to have to come to trial. And he would look out at the parties and he would very sternly say, if you can't get together and enter an agreement on this matter, I will enter an order nobody likes. Well, for the clients, that was a very scary thing because suddenly they felt as if the control of the case was slipping away from them entirely, and the judge was going to do something that they didn't really want to have happen. So there would be a huddle at the back of the court, and the two attorneys and the two clients would be talking, and suddenly things got resolved that hadn't been resolved up to that point. It took me a while in practice before I realized what that judge was saying was just something that was true. In any dispute, who is in a better position to decide how that dispute should be resolved? The parties who have lived it, or a judge who sees it for a few hours? And the answer is obvious. The parties who have lived it are in a far better position to resolve the dispute than a judge who sees it for a matter of a few hours, and it's just one of many disputes that are in front of that particular judge. As I started doing mediation work in the late 1980s, and we would, at that time, when you were a mediator, you did your mediation services for no fee, no pay at all, because at that time in the development of mediation in the United States, mediation was not viewed as a worthwhile endeavor. But as we did mediations of cases, and we were very limited in the kinds of cases we could hear from the courts, but we found out that when we brought the clients together and we did the mediation, instead of clients leaving unhappy, as they generally did from the courtroom, because generally when you're in court and you go through a full-blown litigation and you're walking away from the decision that's been made by the judge or the jury, somebody's not happy, and chances are both sides are not happy. Nobody walks out of the courtroom ecstatic. And here's a life lesson. If you do walk out of the court really, really, really happy, the other side's going to appeal because the judge didn't find a resolution that was acceptable at all. But here you walked out of the courtroom and no one was really happy. And suddenly in mediation, we found out clients were very happy with the outcome. They were very happy with being able to control how their dispute was resolved, maintaining that control in their own hands. And so we spent a lot of time analyzing it, and it prompted me to go back to gain more education on the theories behind conflict resolution and behind mediation. And that's when I got my master's degree, because I realized there was something very powerful about moving through a resolution process that did not involve somebody telling you how it was going to be resolved. And the more you can stay on the left-hand side of this continuum or in the center there at mediation, the more you have the ability to shape the outcome. And that's what makes this process so powerful. So let's talk about the spots on this continuum. Let's start out with avoidance. As you probably know, in your own life, you avoid a lot of conflicts. Well, clients are no different. It's amazing how much they will avoid a conflict before they finally decide to do something about it and move forward. And avoidance is not always a bad thing, particularly with the people that you are working with on a daily basis. If you have someone that has a somewhat annoying habit, is it really worth getting into a fight with them about? Well, maybe not. Maybe it's not the right time or the right place. So avoidance is a common response. And why do people use avoidance when confronted with conflict? Well, the biggest one is that they fear conflict. And it's a fear of losing. It's a desire not to hurt the feelings of others. And in environmental conflicts, that avoidance has some serious consequences. We can talk about avoiding conflict as being one of the causes of global warming and the increased natural disasters that we're having. And certainly avoiding conflict perpetuates environmental injustices. People in marginalized communities, people of color, people in poorer socioeconomic status, they tend to bear the burden of environmental injustices because the toxic waste sites are located close to them. In this country, the Native Americans have borne a disproportionate burden of a lot of toxic waste sites because the reservation lands that they live on were seen as available dumping grounds for a lot of toxic problems. So they have borne a disproportionate burden when it comes to having environmental injustices imposed upon their lands. And those are the kinds of things that avoidance leads to. And so even though avoidance is a useful strategy at times, it certainly doesn't resolve the issue. Let's talk about negotiation. Negotiation can be very informal among friends and coworkers, but it can also be a well-structured communication and bargaining process. And one of my earlier heroes in terms of mediation was a gentleman named Christopher Moore. He's now on the 4th edition of a book that is very well accepted here called The Mediation Process. Chris Moore's in Boulder, Colorado. And he says that, look, negotiation is used when serious differences do not exist to go ahead and get to an agreement, but it's also used to resolve a problem. But if negotiations are hard to start or have reached an impasse, you may need a push or some assistance from a third party, such as in mediation. And if you think about mediation as a way to just encourage negotiation, I think that's a very powerful way to look at what mediation can do. So let's take a look at mediation. Mediation can be very simply defined as facilitated negotiation. There are a lot longer definitions for mediation. In fact, Chris Moore has one that takes about 3 lines of text. But if you boil it down, what the mediator is doing is the mediator is assisting the parties in moving away from positions that were not able to bring the parties to a settlement and allow them to perhaps hear each other and see each other and understand what each other's true interests are rather than their positions. There are a couple of kinds of mediation we can talk about. The one that Chris Moore teaches and the one that came in this country first was something called problem solving or facilitative mediation. That is a style that is used by a lot of mediators currently. It's a style that's taught quite commonly in law schools. And in 1994, a couple of authors named Folger and Bush wrote a different take on mediation that they called transformative mediation. Transformative mediation really talks more about the relationship between the parties and working on that relationship rather than working on the problem that brought the parties to the mediation table. Transformative mediation includes restorative justice as part of its coverage. And I'm going to come back to restorative justice in a little bit because I think it may provide a model for us to deal with some of the environmental issues that are plaguing us now. But mediation is a way to hang on to the control of your dispute because the mediator has no power to settle anything. And it's the parties who have the answers and the parties who can move this process forward and come to a resolution that everyone can be comfortable with, can support. They're not looking for loopholes. They're not looking for ways out of it. You know, it's funny when you have a judicial outcome after you've gone through court, inevitably one of the clients on one side or the other, or perhaps both, would go to their counsel and say, okay, should we appeal? How can we get out of this? What's the minimum we can do to respond to what the court has said? And it's those kinds of responses, excuse me, I jumped ahead of myself. It's those kinds of responses that cause problems for our judicial system. All right, let's talk about arbitration and litigation. Those are our last two stops on the continuum. Certainly, arbitration is a time-honored way of resolving particularly commercial disputes. And we have found some courts in the United States that are ordering arbitration as an outcome for the disputes that are in front of them. And arbitration is a perfectly good tool. The problem with arbitration is that it's possible for the disputants to lose control of their dispute because now they've handed it to an arbitrator. It's kind of similar to two siblings, brothers and sisters, that get into a dispute with one another, and ultimately a parent has to come in and settle it. Well, the parent may settle it in a way that neither of the siblings likes, and if they'd have been left to their own devices, they could have probably come up with a better settlement. And of course, when you go into the court system and you've spent all that time and money in preparation for trial, you go through trial, you may or may not have an outcome that is acceptable to your client because the court only sees that case for a few hours. However, we need to talk about some of the advantages that you have to arbitration and litigation. Those advantages are, first of all, finality, okay? You do finally end the dispute. You do finally have a conclusion. It also sets a precedent, and setting a precedent is a very valuable thing in our legal system because it gives us a way to look at future cases that are similar and to let us know how the courts are going to be resolving that. Finality may or may not happen after a trial because there's always the possibility of an appeal. And of course, you're well aware of the disadvantages of going into litigation, the time and the cost and the emotional toll that it takes on parties. I never had one of my clients say to me, gosh, I'd like to do that trial again. It was just so much fun because it just isn't. Also in the courtroom, there is absolutely no value given to the relationship that exists between the parties. And that relationship may be the very key that you needed to resolve the case, but there is no value afforded the relationship in the judicial process. So what is environmental justice? Well, I have a short video on environmental justice that I think gives a quick answer. And I know many of you are studying this area and you're probably very familiar with it, but for those of you who have not yet been exposed to it, I think this short video will help you understand the concept of environmental justice.
Environmental justice really reflects the fundamental reality that vulnerable communities are all too often subject to the disproportionate burden of pollution and contamination. At the end of the day, when we're talking about environmental impacts, at the heart of it are real people's lives. And if you think about one child who's in her home that maybe has lead paint on the walls, she's drinking water from the tap that might have lead contamination in it. She plays in a playground that has arsenic in the soil and is developing asthma because of the polluting facilities next door. She goes into her school that has mold inside. These are real things that happen on an everyday basis. Not everybody has the ability to simply uproot themselves from a community where they've lived for decades, where their families raise them, where they raise their children. People don't have the financial mobility necessarily to simply get up and go. How do we combat environmental injustice? There are things like litigation. That means continue fighting in the courts, continue fighting to strengthen existing legislation, fighting to ensure that existing legislation is actually being enforced. Things like community organizing, public education, mobilizing the base, and elevating voices. There's also things like using media as an outlet to get your point across. In today's day and age, especially with this administration, I think there are an enormous amount of hurdles in how to address environmental injustices. But the reality is we have to keep fighting. great gains do not occur overnight. They take sometimes decades. I truly believe that environmental justice is the modern day civil rights issue of our time.
So when we are looking at environmental injustices, and you'll notice that that video kept talking about fighting, perhaps there's another way. And that's the way that I would like to introduce you to, and that is environmental mediation and being able to resolve these issues in a way that can help the communities that are being impacted by this issue and help them in a way that they don't have to bear a disproportionate amount of the burden for environmental issues. So let me move into, I very purposefully picked two different environmental mediations from the United States that I think help illustrate the issue. The first one is the Storm King mediation. The Storm King mediation occurred in Upper New York, and I want to give you a little bit about the background of that mediation. This is a multi-party environmental dispute. In fact, at one time, there were 19 parties involved in this mediation. This was a huge effort before a project began and before there was the negative environmental impact on this project. This project was going to be placed along the Hudson River, which you see in this picture, and it would have involved electric generation facilities, nuclear facilities that had huge cooling towers. It would have impacted the fisheries. It would have impacted the total environment of this area, and the desire was for development and electric generation. So there were 19 parties at this mediation. It was a contentious mediation when it began. And there were threats of lawsuits both in the federal courts and in the state courts. But there was also the desire to come to some sort of resolution because the animosity toward the power companies was spreading. And the power companies realized that if they pushed this project through, they might actually lose more than they could gain by moving this project forward. I picked this dispute because it is an example of mediation occurring before environmental damage has occurred and occurring in a multi-party situation. So let's talk about why this mediation worked. The conditions for success in Storm King in some ways were unique. First of all, you had a mediator in this case that had an incredible status with all the parties. It happened to be Russell Train, who was the former administrator of the Environmental Protection Agency in the United States. He brought together the parties. And the first thing that they did was that they negotiated the ground rules of the mediation. And in negotiating those ground rules, all the parties that were at the table came to an agreement of how they were going to proceed with this mediation. One of the most important ground rules, there were no media releases, no internet, no print, nothing that came out of this mediation except by the mediator. In other words, there was no attempt to modify public opinion through using any of the traditional media sources. Another important ground rule, all the parties who could affect the decision were present. That's why there were 19 parties in this mediation. There were state regulators and federal, national regulators. There were cities, because New York City was represented in this mediation because it was the beneficiary of the power that was going to be produced here. There were the power companies, there were environmental groups, there were fisheries groups. All the parties who could affect this decision and who could jam it up by going to the courts, they were all present. And among those parties, all of them could speak for and bind the groups they represented. They had the authority to move forward with a solution on this matter. That's a very important concept in any mediation. You want to make sure you've got the right parties in front of you. I've been in mediations where somebody said, oh, wait a minute, I need to call my manager and see if I have authority. And all that does is interrupt the flow of what is going on in the mediation. So you want to make sure that they could speak for and bind the groups they represented. There was a willingness to compromise. And the tone that was set in this mediation is that all the parties were willing to make good faith offers and consider counteroffers. So they were able to actually sort out the Storm King controversy in that mediation. Ultimately, different projects were built to get the electricity that they needed, and the Hudson River and the Hudson River area was unaffected by the way that this generation would occur. And no marginalized communities were impacted, and no fisheries, wildlife, or the forest or river itself were impacted by the outcome of this mediation. Let me talk about another one. This is a very different setting for a mediation because the damage has already occurred to the environment. That damage was caused by some of the activities of Dow Chemical, and the Environmental Protection Agency, through an act of Congress, had set up what they called the Superfund cleanup. It was money set aside that would be matched by the company that caused the pollution, money set aside to clean up the environments that had been injured by the actions of the chemical company. These were incredibly contentious legislation or legislative outcomes, and most of them wound up in the judiciary, and they had to be sorted out through the court system. However, this was a successful mediation because there was a mediator who got involved with the Superfund and Dow Chemical. This was a two-party mediation, and actually Dow had brought an action against the EPA trying to compel it to pay its percentage of the cleanup of 10 different sites across the United States. Here's just a quick picture of all these Superfund cleanup sites that are present across the United States. And this particular two-party mediation lasted a long time, but it was successful. And let me explain why it was successful. First of all, there was a tremendous respect for and stature of the mediator. This is a gentleman I know very well. This is Mr. Dick Calkins. He started INADR. He just turned 90 about a week ago. And when he was doing this work between Dow and the EPA Superfund, he knew this was going to be a long haul. It was going to be a mediation that, if it was going to be successful, would need to take its time. Government agencies, by their very nature, are tough as negotiation partners because they tend to be stuck in their ways. They tend to think they have all the power. They tend to think that they don't have to bend that much. And so Dick knew that this was going to be a long mediation. And there were 10 sites with a tremendous amount of money involved in each of the cleanups of each of these sites. As I said, Dow had already filed an action. And so a series of continuances were sought because the mediator realized that the parties could come to an agreement. And so he very wisely said, look, let's take on one of these sites first. And let's see if we can't mediate it. And because they took the arbitrary time limit off, they were actually able to use 18 months to put that first agreement together. And all of the parties who could affect the decision were present, and all of the parties that were there could speak for and bind the groups that they represented, much like the Storm King situation. But remember the different posture this one is in. This one is after a lawsuit has already started, after the environmental damage has already occurred. What happened was that the first site settlement became a template for the settlement on the other sites. And both parties realized that if this first site didn't settle, a prolonged litigation was going to follow. And it was really interesting. Dick has said that both Dow Chemical and the EPA realized that after they settled that first site, it was going to be so much more efficient and cheaper for them to settle the other sites that were involved in this litigation, that they sat at the table and got the rest of these sites sorted out in fairly short order. The trick was to get that first site, a settlement put together on it. And that was one of the very successful mediations he was involved in. And again, a lot of it had to do with the status of the mediator. He was the dean of Drake Law School, very successful attorney, and he brought the parties together and was able to negotiate and save the taxpayers and Dow Chemical a whole lot of money. So when we talk about environmental mediations, we need to talk about what is success. The two mediations that I've talked to you about had very different outcomes, or very different beginnings, because they were in different stages of the settlement process. So how do you define success? Some of that's up to you. What do you consider success to be in a mediation? Now, I'm going to do something that I hope all of you will do with me, and that is I'm going to give you an opportunity to see what kind of mediation you would prefer. What I need for you to do, if you will, is take out your mobile phones and take a picture of the QR code, or else type that very short bit.ly link into your browser and go to a brief 7-item test, survey actually, about what kind of mediator you would be. So I will give you about 3 or 4 minutes to go ahead and do this. Click into that, because it will tell you whether you lean toward a facilitative mediator, or you are a facilitative mediator, or you're a transformative mediator. And part of your definition of what's successful in a mediation depends on how you look at that mediation. So go ahead and take a couple minutes, click on the QR code, take the short test that comes, a survey that comes with it, and I will be back to you in just a minute. We'll talk about the results. I always think it's important for a presenter to involve the audience, and this is one way I could involve all of you in this process. So take this short survey and see which way you lean. Don't try to outguess it, just give your first response.
Sir, I attempted the same.
Okay, did it work?
Yes, sir, it worked, sir.
All right, excellent, excellent. So I think most of you've probably had enough time to do the little survey, and it gave you some results.
Yes,
it
sir.
Allowed you.
It did.
Yes. Okay, so let's move on and talk about then restorative justice. It is a form of mediation. It's done in the criminal law context. And how are we going to equate that to what's going on in environmental law? Well, the most common response to serious environmental harm is the criminal justice system. The problem with that, it generally fails to give victims a voice. And restorative justice is a way that we can look at the criminal law process and allow people who've been impacted by crime to have a voice. And we sometimes call this victim offender conferencing or victim offender mediation. And what are the advantages of this? Well, it facilitates a communication between the offender and the victim. Here's the big one. It shifts the focus from blaming and punishing the offender to meeting the needs of the victims. And if you can go through the process of conferencing and talking with offenders, and they realize the impact of their action, you might even move to an apology. Now, you don't have to demand an apology, and certainly forgiveness is not the response by the victim. But if you can get to a point where you actually start talking about having a genuine apology, some healing can begin from that incident. There is the potential then for identifying forward-looking restorative outcomes rather than focusing on punishing the wrongdoer. There are some disadvantages to restorative justice conferencing. Not all situations are appropriate for that. It can take longer and be more costly than court proceedings, and reparation may not be achievable. I mean, the offending company may have gone bankrupt, may be out of business. There are lots of ways that this might not work. But this is from a new article published in the South Wales Law Journal. And that article talks about the potential of restorative justice in environmental situations. And I think it has a lot of potential. And I want to talk about how that might play out. The conditions for success in restorative justice in your typical criminal process are discussed in the United Nations Office of Drugs and Crime Handbook on Restorative Justice. The UNODC has published a handbook, and it said, look, there are 4 conditions that need to be in a restorative justice process. First of all, you have to have an identifiable victim. You have to have voluntary participation by the victim and the offender. You have to have an offender who accepts responsibility for their criminal behavior. And of course, there has to be non-coercion of the parties. So these are the typical factors in a criminal case. The question is, how does this play into an environmental restorative justice mediation? Well, first of all, that first question is more complex. Who's the victim in an environmental restorative justice process? Who speaks for things like rivers or forests? Who speaks for the groundwater? And I know that we have environmental groups that try to promote those interests, but are they the right party to have in the restorative justice process? Those are questions that don't exist in a criminal justice process because you've got an identifiable victim. In an environmental restorative mediation, you may have entire communities that are the victim, and you need to have someone who will step forward and represent those communities. There are also victims that might not want to participate in such a process, and you certainly can't force the victims to participate. Also, in looking at the offenders, they run a wide range, because offenders may be individuals or corporations that are one-time offenders. You know, take an oil leak from Exxon Valdez or something like that, when the tanker ran aground in Alaska. That was a one-time thing. And do we treat those kind of offenders differently than the repeated behavior offenders who do this over and over again? Remember, I said Dow Chemical had 10 Superfund cleanup sites to restore. How do you treat an offender like that versus someone who has a one-time problem and causes environmental damage? Finally, are the offenders really prepared to accept responsibility? And do they have the ability to mitigate the impact? Again, They may have gone out of business. They may have gone bankrupt. It may be a different corporate entity. You know, things happen that take that responsibility and move it, and it's more difficult to talk about meaningful mitigation of the impact. So again, I think there is potential here. And the authors of this article point to a couple of cases they have seen in New Zealand and in other places where restorative justice was the perfect vehicle to bring this back, this environmental problem back into focus and help the victims of the environmental harm to gain not only a sense of dignity, but to gain some financial repair for what has happened to them and start that healing process. So do I think there's a role for mediation and environmental justice? Most definitely. I think I'm pretty close on time, so I'm going to go ahead and give you a quick conclusion and open the floor for questions. Here's the deal, people. We live in one world, and that world is a world that we all share. And as we are dealing with some of these serious environmental problems that exist around the world, and not only in India and in the United States, but in other places as well, we need to realize this is one world. And mediation is a vehicle that we can solve some of these environmental issues. We can maintain the control of the result. We can have the parties themselves come up with the best answers for how to resolve these kinds of issues. And I am speaking to a group of people that I know will have the most impact out into the future. All of you that are in school now, you're going to carry these lessons and these thoughts out into your future practice. You are the hope of the future. My generation has fallen short, and I realize that. We were very idealistic in the 1970s when we started Earth Day, and we started all the things that people of my generation did, but we have fallen short. We've dropped the ball. And we are depending upon you, this next generation coming up, to be our future leaders. You folks are going to be the ones that will take this process forward and make our world a better place for you and your children. We live in one world and we need to treat it as such. Does anybody have any questions? I want to again thank you for the invitation and thank you for considering mediation as a way to achieve environmental justice. The slide contains some information on how to contact me, and let me jump out of the share here so I can see all of you again. I have not been monitoring the chat. I don't know if there are any questions in the chat or not.
Thank you so much, sir. I had received 2 or 3 questions from email, sir. Basically,
Okay.
we did not keep the chat box open because the participants would kind of disturb the speaker. So, right, for the better lectures, we had closed it down. But I received 2-3 questions to the method of email, sir. So the first question to you is that, sir, whether this concept of transboundary pollution, which is caused by one country, and that pollution extends to the another country. So where both the countries should sit together for the concept of the mediating the matter that one developing country is polluting the other underdeveloped nation. So how does one country negotiate or mediate upon the environmental justice? How do we go about that?
That's an excellent question. And you know, pollution doesn't obey boundaries. Pollution occurs wherever it occurs. And we had a similar situation between us and Canada with regard to acid rain. Acid rain was being caused by sulfur emissions, and the sulfur emissions were causing a lot of problems for the forests in Canada and the United States. Both countries realized that this was a problem that they needed to jointly address, and they were able to do so because they recognized the value of addressing this together. It didn't do any good for just one country to address it. They both needed to address it. But you're right, there are situations where one country takes advantage of another by casting off its pollutants and environmental problems downstream, if you will. And I do believe that with the increased value afforded to mediation, look at the Singapore Agreement. Look how many countries are signing on to the Singapore Agreement to enforce mediated results from commercial disputes. I do believe that the growth in mediation and the trust afforded to mediation, as indicated by the development and growth of the Singapore Agreement, kind of mirrors the growth that occurred with result to the honoring of arbitration agreements across international boundaries that happened with the New York process. So I think we're seeing a time when mediation can be a vehicle to reach across boundaries and work with those kinds of transnational problems. So that was a great question. Thank you for that.
Thank you so much, sir, for answering the question. So the next question to you is that in India, we basically use mediation as a ground for resolving dispute between the matrimonial disputes. How can we inculcate the culture of mediation and environmental justice in India itself?
I sort of figured I would have that question because what's happening in India kind of mirrors what happened in the United States from the 1980s through about the end of the 1990s. When I first started doing mediation, the only cases we were allowed to mediate were domestic relations cases, and only cases that had already had a divorce decree and the parties were seeking a modification of that divorce decree. Talk about a limited set of cases. But from those cases, parties began to realize the value and the impact that mediation could have. When I first began mediating as an attorney, I was part of a team called Transitions. We would pair a mental health professional with a legal professional, and we would be the co-mediators for these cases that were seeking modifications of divorce agreements. When the parties walked out of the mediations and we were able to come up with an agreement they had wanted, they would circulate those proposed agreements back to their attorneys if they still had attorneys, and then to the judge. Well, the judge would automatically sign off on these changes because the judge had seen the case before and didn't want to see it again. And so the judge was more than delighted to make sure that that change in the divorce decree was accepted by the court. From that, people began to realize the power of mediation. That was a humble beginning. Oh, another funny thing. In the beginning, lawyers viewed with disdain the mediation process. They said, oh, mediation will never work. You've got to go to court. You've got to hash these things out. I think the fact that you're mediating is kind of a silly thing for you to do as an attorney. Now it's really interesting. Lawyers want to own the mediation process. They want to be the only ones that are doing mediations. And in the state of Georgia, because each state was allowed to develop their own mediation process sort of independently, state of Georgia very early on realized that there are other disciplines out there that are just as capable of being mediators as attorneys. And when you go to a continuing education program for mediators, about half the house is lawyers, and the other half of the house is mental health professionals, licensed counselors, psychologists, social workers, and so forth. And the law in Georgia has allowed for those folks to be mediators too. And the desire to have mediation has spread from the divorce arena into many other arenas of practice, including industrial relations issues and other more complex things that come with larger groups and larger audiences. So yeah, I think India is on the way. I really think from what I'm seeing from some of the schools we work with, mediation is getting a lot more credibility in India, and I think it will continue to grow. So perhaps it's just a matter of time.
Thank you, sir. And the last and the foremost question for the day by Shubhabi Malhotra in the chat box is, can we use mediation in saving the trees from being cut for commercial purposes?
I hope so. But the financial interests of those who want to log the forest, who want to cut the trees, have to somehow be met in another way. They have a strong financial interest in logging those trees and making that money. And we've got to, first of all, encourage them to see the value of the forests as they exist and to use sustainable harvesting methods. In the United States, the environmental laws that we passed dealt with this problem. Some of the forests we have, particularly in the West, where there's a lot of logging that occurs, those forests were actually protected by law. And then we entered into agreements with logging companies for sustainable logging of those forests. So sometimes you have to have a bit of law in place before you can successfully mediate. You know, mediation occurs, I've said this often, mediation occurs in the shadow of the law. And without having some law in place that you can resort to if you need to, mediation is not as effective. So one of the things that needs to happen in your country is that there needs to be some protective legislation for the forests, and then you can start talking with the logging companies and those who want to use that forest to use it in a sustainable fashion.
Okay. Thank you so much, sir, for answering the questions. Now we
Thank
have
you.
our Dr. Ashish Kumar Singhal, sir, senior member of the Center for Environmental Law, as well as the Associate Professor of Law in the ICFI Law School, for the vote of thanks. Over to you, sir.
Thank you, Vishal, sir. Good evening, everyone, one and all present here. Chief guest of today's international special guest lecture, Mr. Kenneth Frank, Professor and Director of the undergraduate degree program in conflict resolution and legal studies at Brno University, Gainesville, Georgia. Brigadier Rajiv Sethi, Honorable Registrar, ICFI University. Assistant Dean, ILS, Mrs. Monica Kherola. Faculty members and all the students from ICFI Law School, ICFI University, Dehradun, and from other colleges of India and abroad. I, Dr. A.K. Singhal, welcome all of you on behalf of ICFI Law School, ICFI University, Dehradun. It is such an honor for me to get the opportunity to thank you all present here. On behalf of ICFI Law School, the ICFI University, Dehradun, I extend a warm welcome to the people of gathering. I would like to express my gratitude to our Honorable Chief Guest to take out time from his busy schedule to grace the guest lecture on environmental justice, a call for mediation. Thank you, sir, for inspiring and encouraging us with your kind words. You have given a brief about various provisions of environmental justice and mediation. You described as conflict and the mediation, choices when conflict arises. A special thanks to Ms. Anushmi Jain and Mr. Vishal Bera, faculty convener, Faculty of Law, for immense support and organization to make the guest lecture a great success and a great learning session. Thank you, sir. Thank you, madam. I must thank the entire team of ICFI Law School, faculty members, students for working hard to make the guest lecture a great learning session. Thank you, everyone, once again for making it a great learning session. Thank you. Thank you once again. Thank you all.
Thank you, sir.
Thank you, sir.
Thank you very much, Dr.
Kenneth,
Singhal.
sir.
Thank you for your kind words.
Kenneth, sir, I would like to request that in future we can have a small exchange of faculties from our university and your university for online lectures to our students, so that our teachers get the opportunity to teach your university in online mode, and even the whole faculty under you teaching law can teach our students, so both the students can benefit for the same, sir. I think in future we can take upon the same, sir. We can have some good deliverance of lectures from both the ends, sir.
Well, I would welcome that. I think the opportunity for us to learn from each other is a wonderful opportunity, not only for the faculty, but definitely for our students.
Students, sir.
And I'm just delighted to have been asked to participate today, and your invitation and has been most gracious, and your professionalism and just being able to work with such a fine faculty and students has been very, very rewarding for me.
Thank you, sir. We'll look forward for some more great connections. As I said, the motto of a university is to connect more professionally and develop ourselves as well as the students, sir. Thank you so much, sir, for sparing your valuable time with us, sir. Thank you so much, sir.
Well, thank you for the invitation, and I do want to extend the invitation for you to participate in INADR activities.
Surely, sir.
We would love to have a team or two of your students participate in the mediation tournament that's coming up. It's being hosted by Loyola University in Chicago in March, but it is a virtual tournament. And you are certainly welcome and encouraged to participate. We'd love to have your fine students be part of that event.
Surely, sir.
All right. Professor Berra, can you stay on for just a moment?
Yes, sir, I can. Yes, sir.
Good.
Praveen ji,
Good.
please wait. Don't close the meeting. Yes, sir, I'm there.
Okay. I just wanted to thank you for your kindness, and I appreciate what we have accomplished together, and I want to send you greetings from Dr. Mary Lou Frank too.
Oh, thank you so much, sir. Thank you so much.
She was very helpful in connecting us, and certainly she's looking forward to more opportunities to work with you.
Okay. She actually built us the bridge between me and you, sir, and we both got connected, sir, just because of ma'am itself.
That's right. That last slide I had up, I saw a brief request for that slide to be put up again, but I didn't want to interrupt the thank you. So somebody was looking for that last slide. My contact information is on there, and the organization that Mary Lou and I co-founded, the Transforming Mediation, the information is there for that contact as well.
So, and one more thing to bring to your notice, we also have a Center for ADR Excellence, Alternative Dispute Resolution, in our ICFA University also. So we'll be trying to get connected to you more and more so that we build a more good professional relationship between ourselves and the university, sir.
Oh, that would be wonderful, and we would certainly welcome that. But it's been a real pleasure to be with you, and Ms. Jane, you did a lovely job of organizing the Zoom meeting for us, and you are a professor at the school too. Did I understand that correctly?
Yes.
What area do you teach in?
I deal with media law and constitutional law.
Oh, okay. Now we're talking some serious law. When we're talking constitutional law, that's serious business. So, okay. Well, thank you very much.
Thank you, sir.
Really nice.
All right.
Thank you.
All right. Have a nice day.
Same to you, sir.
Nice evening. Okay.
Yeah. Thank you, sir.
Bye-bye.
With your prior permission, can we close down the meeting, sir?
Absolutely.
And we'll stay in touch. We'll stay in touch, sir.
All right. I'd appreciate that.
Yes, sir. Thank you, sir.
Okay.
Take care. Good day, sir.
Good day.
Bye-bye,
Thank you.
sir. Thank you.